Hello guys, welcome to LawPutra YouTube channel. Our today's topic is adultery as a ground for divorce. The Supreme Court has struck down 158-year-old section 497 of IPC in the case of Joseph Shine versus Union of India and ruled that adultery is no longer a crime. The five judges bench, headed by Chief Justice Deepak Mishra, has said that Section 497, which deals with adultery, is absolutely manifestly arbitrary. He stated that adultery can be a ground for divorce, but not a criminal offense. Adultery as a ground for divorce in India has been defined under Section 13, subsection 1 of Hindu Marriage Act 1955 as the act of having voluntary sexual intercourse with a person who is not the spouse of the respondent. Adultery may be defined as the act of a married person having sexual intercourse with a person of opposite gender other than the wife or husband of the person. Personal laws all around the world condemn adultery, and it is considered as a ground for divorce or separation. The essential ingredients in an offense of adultery are that there should be an act of sexual intercourse outside the marriage, and such intercourse should be voluntary. However, in the case of Subarna versus Saraswati, the Madras High Court held that where an unrelated person is found with the wife after midnight, the same would be inferred as adultery. But what Hindu law states on adultery as a ground for divorce? The spouse who wants to file a divorce petition has to substantiate the statements with proper evidences. Before the enactment of Marriage Laws 1976, adultery was treated as a conduct of grave immorality. But it was a thing of grave shame irrespective of the gender. However, it was not a ground for divorce. Now, under Hindu Marriage Act 1955, either party to a marriage may present a petition for divorce under Clause 1, subsection 1 of Section 13 on the ground of adultery of the respondent. In the case of adultery, direct proof is difficult to get, and one has to rely for proof thereof on circumstantial evidences, and the same may be sufficiently proved from which adultery may be inferred. The burden of proving adultery in a matrimonial case is always on the person who makes the allegation. Now, how can a person be defined as adulterer? Adulterer, as a general rule, is proved by presumptive proof based on circumstantial evidences, non-access in the birth of children, contracting venereal diseases, and mere suspicion is not sufficient evidence. Now, let's talk about what are the instances of adultery. In the following cases, the plea of adultery has been upheld by the courts. Number 1, wife had been absenting herself from her house for some time and was seen in the company of a stranger to the family of her husband without reasonable explanation or any explanation. Second, unrelated person found alone with the wife after midnight in her bedroom in actual physical juxtaposition. Third, evidence on post-suit adultery is admissible to prove and explain other evidence given in the case and to show the character and quality of previous acts. Fourth, admission of adultery by wife through letters. Testimony of disinterested witnesses to the effect that they had seen the respondent sleeping together with another person in nights is sufficient to prove adultery. 6. A solitary instance of voluntary sexual intercourse by wife with other person is enough. Now let's talk about what are the instances of no adultery. In the following cases of plea of adultery has been rejected by courts. First, no conclusion of adultery where the wife was found going on the scooter of some other person or talking with some other than her husband. Second, no corroboration to prove adultery of wife when she remains in a room with door though shut but unbolted at 10 p.m. with another person when the mother of the husband and 5 grown-up children were present in the house. Third, mere fact that some male relation writes letter to a married woman does not necessarily prove that there was illicit relationship with the writer and recipients of the letters. Fourth, wife becoming pregnant after husband had undergone vasectomy operation without proving that operation was successful. No illicit relationship of wife can be presumed. 5. Serious doubts may be raised as to the allegation of adultery of wife when the husband makes no such allegation in the notice for divorce prior to the filing of the suit. 6. where the husband files the petition for divorce 8 years after he came to know that his wife has committed adultery and has not explained the reason for the inordinate delay alone. 7. Mere presence of alleged adulterer in the bedroom of the parties does not constitute an adulterous act. 8. Allegation of the husband that he saw his wife talking with other person on 3 occasions in the daytime without any physical contact or sufficient. Now, to conclude the above explanation, adultery has always been discouraged throughout the history of mankind. But there is no steadfast rule that can be commonly used for all adultery related cases. The court has the discretion to treat each case on its own merits and demerits. These might include children, society, familial consideration, and also the economic status of the parties. Thank you so much.